Thank you very much, Clement. My name is Peter Njeru. I'm a director of the Chartered Institute, but I'm also a fellow of the Chartered Institute and a practicing advocate at Kaplan and Stratton. We want to thank you very much for registering and joining. We have a fairly good turnout. So far, about 80 of us have joined. And we hope to have a meaningful engagement. We will keep the chat open so that anyone with a question as the presentations and discussion goes on can type the questions there. I'll keep checking, and we'll have a session for question and answers. I kindly request us to keep our microphones muted unless if and when you're invited to speak. I'll go straight ahead to the session for today. We are discussing managing cost in small claims arbitrations and also managing cost in arbitrations generally. We are privileged to be joined by two very experienced arbitrators, and I'll introduce the first one. I'll start with the lady. That is Kethi Kilinzo. Kethi, are you there? Before I introduce you and you're not.
Yes, I'm present, and I'm happy to hear I am experienced. Thank you.
Experienced arbitrator and practitioner. Kethi is an advocate of the High Court of Kenya. She is also an affiliate of the Association of Certified Chartered Accountants, United Kingdom. She's an arbitrator and mediator accredited by the Chartered Institute of Arbitrators. And she practices law as a partner at Kilinzo and Company Advocates. We are also privileged to be joined by Mr. Samuel Nderitu. Sam, can you hear me?
Yes, Peter, good afternoon. I can hear you.
Afternoon. Sam is a chair emeritus of the Chartered Institute of Arbitrators. He served as the chair of the branch in 2019 to 2021, and he's also served as a director of the Institute for several years. He's a board member of the National Center for International Arbitration since 2021. He's also an advisory board member for ADR Africa Network, Musahila International Center for Arbitration and Dispute Resolution in Pakistan. He was also a founder director of the International Chamber of Commerce, Kenya, and served between the year 2017 to 2025. He is in the panel of arbitrators and mediators at the Nairobi Center for International Arbitration, Chartered Arbitrators Kenya, China Maritime Arbitration Commission. He also has the right of audience of the Astana International Financial Center Court, AIFC Court, and International Arbitration Center, Kazakhstan. His service extends to being a member of the Law Society, continuing CPD Committee, and a convener of the Law Society ADR Committee. He's also accredited as a trainer and examiner of arbitration and mediation by Chartered Institute of Arbitrators, London. So as you can hear, he has a very good profile, and we'll be privileged to hear his insights, even as we discuss today's topic. We have quite a number of issues that we hope to address, including the cost sensitivity of small claims, leveraging documents only, proceedings, some of the expedited arbitration procedures. We also want to look at drafting cost-efficient dispute resolution clauses. We'll also speak about case management techniques for arbitrators. We also touch on technology as a cost reducer. We hope to touch also on cost allocation in small claims, promoting accessibility and user confidence. Also the issue of appointment of sole arbitrators as a cost-reducing mechanism. And also we'll touch on some of the common pitfalls in drafting arbitration clauses. And if time permits, we'll discuss what a model framework clause should be. So to start us off is Samuel Nderitu. He'll generally speak about drafting and the choice of forum together as a general topic in managing the cost in small claims arbitration. So Sam, the floor is yours. As he starts, I remind you that if you have any question, kindly just type it in the chat box, and then we'll deal with it at some point. Thank you very much.
All right. Good afternoon, colleagues. Thank you very much, Peter, for that warm introduction. I'm in a borrowed space somewhere at Strathmore University where we have the mediation summits ongoing, but we have to multitask. So this is equally important, and I think it is only right that we are able to have this conversation. As indicated by Njeru, Director Njeru, we are here to have a conversation about managing costs in small claim arbitrations. And this being an afternoon session, I know it can be a bit slow or sluggish. So what I have decided to do is share my cup of coffee with you as we have this conversation. So allow me to project my presentation so that we're able to work together. I have no intention of inflicting death by PowerPoint on anyone, so I will try and just give some sound bites as we go along so that we're able to work together. So firstly, it's an issue of proportionality, procedure, and practical drafting. Because if you don't have a good clause, then you will not have a good outcome. There is a study that was done by the ICC Commission on Arbitration and ADR, and they issued a report in March of 2018, where they found that the cost incurred by the parties in presenting their case constitute the largest part of the total cost of international arbitration proceedings. And there was special emphasis, therefore, that there is need to take steps aimed at lowering the cost connected with parties' presentation of their cases. Now, whereas this was a study done on international commercial arbitration, the same is equally true for domestic arbitration, that the cost of parties presenting their case actually form the bulk of arbitral costs. Now, what you'll note from the onset of this conversation is that the topic we are about to discuss is not laid out by the model law, and therefore you will also not find it in statutes. It is mentioned somewhere, for example, if you look at our Kenyan Act, Section 20, subsection 2, it says that where parties don't agree, then the arbitrator has the duty to take some procedural steps to be able to conduct the arbitration in a manner that takes care of time and costs that are associated with arbitration. So in this presentation, you'll hear us make reference to various rules of various institutions that we'll be using as benchmarks for what can be done. And before we even get into why this discussion matters, what are small claims? Now, there is no definition of what a small claim can be. But between you and me, I'm sure for those who've had experience in arbitrating over matters, you find sometimes that there are standard insurance contracts. All of them provide for mediation, but then say, or the matter can be referred to arbitration. So mediation in the insurance contracts is not made mandatory. It's an option, and people most times skip that step and go straight to arbitration because they want speed, they want finality, etc., etc. But you might find yourself sometimes in absurd situations, whether it is motor insurance, whether it is medical, you're representing a claimant that has disagreed with their insurer, and all they want to recover is maybe 100,000 Kenya shillings, 200,000. You've done sales of land, you've done sales of apartments, and right there you have an arbitration clause that is talking about arbitration using ICC rules with 3 arbitrators, and yet this is a plot somewhere in Kamakis where the going price maybe could be 6 million, and what you're fighting about is reimbursement of 10% deposit. So again, talking about of a dispute less than 500,000 or less than 1,000,000, and you are burdened with LCI rules, ICC rules, and this is why drafting matters. So going back to the question of what is a small claim, again, as I've said, no statutory interpretation is given. Even the rules do not say what is a small claim. But if you look at FCIArb rules 2020, which provides I think is rule 77, that provides for the expedited proceedings. It says a dispute that does not exceed 10 million Kenya shillings, where parties agree, that kind of dispute can be taken through the expedited procedure. And 10 million is the aggregate. It includes the claim, counterclaims, and the costs that are attendant to that arbitration. So would you say that 10 million, a claim of 10 million Kenya shillings, including costs? So that's a claim maybe of 6 million, together with attendant costs and counterclaims. So is that a small claim? If you look at the Singapore International Arbitration Center rules, they have something, for us, we call it the expedited procedure. They call it the streamlined procedure. And they say that applies by agreement of the parties. And then they say something interesting. They say that streamlined procedure applies automatically for matters where the amount is in dispute does not exceed 1 million Singapore dollars. I know we've been told we are going to Singapore, but you would want to know, as of yesterday, the exchange rate of the Kenyan shilling to the Singapore dollar was 108 shillings. So that would simply mean that the matters under the SIAC rules that automatically qualify for the streamlined procedure are matters of about 108 million Kenyan shillings. What you might want to know about the Singapore rules is that they specifically then go on to provide that for the streamlined procedure, the award will be made in 3 months from constitution of the tribunal. Compare that with ICC rules that give timelines of 6 months from settlement of terms. So from 3 months from constitution of the tribunal, it must be done by a sole arbitrator, and it is by way of written submissions and documents only. And when we say documents only, it's not the Kenyan style where you say it's documents only, then you still say you want to bring a witness to produce the document. So under the SIAC rules, there's no document production, and there's no filing of expert or witness of fact evidence. So that, to them, because of the economy, is how their rules are stated. But as you can see, we even have, and I know you have experienced this, when I served as the appointing authority between 2019 and 2021, I would see parties having claims, some even of 80,000, but there's an arbitration clause. And what you would know is that whenever there's an arbitration clause, the party that is in default will want to frustrate the claimant. So even if it is 80,000, they say the clause says arbitration, let's go to arbitration. So you will see later on, we'll be talking about this ICC report, and I hope I will share it with the Secretariat, but also Google it, and you'll find that it gives very practical tips about managing costs. So why does this discussion matter? Small claim arbitrations must remain proportionate to the dispute, in the value of the dispute, and also complexity. And therefore, any process that costs more or as much as what parties are claiming is a procedural failure. And that is why we will be talking about not just drafting, but then the procedures that are being followed. So a cost proportionate procedure should not be a luxury. It should be the foundation of access to justice. So even though Section 19 talks about parties being treated fairly, 19A talks about parties being given a reasonable opportunity to present their case, you must always, as an arbitrator or even a party representative in arbitration, remind your arbitrator that it should be cost proportionate, and there is no need of taking steps that are necessary in a small claim arbitration. Avoiding big procedures. If it's a simple sale of land whereby I sold a piece of land to you, you paid the deposit, and you have not paid the balance. And we have an agreement that clearly says the steps that should have been taken, and we have filed all the documents. Why do you have these things that you borrow from the civil procedure, where we say we need interrogatories, further and better particulars, we need experts and experts for a breach of contract for sale of land? So all these things that are there in big arbitrations as procedural steps that should not be included in small claim arbitrations. If you look at NCIA Rule 14, the rules of NCIA Rule 14, they reflect Kenya's commitment to proportional arbitration. So this is why we are saying the core principle is about dispensing justice in a cost and time efficient manner. So when you go to the issue of being cost sensitive in small claims, when you go to document production, do you need to go through the whole issue of issuing a red fund schedule and asking the parties to follow the red fund schedule in production of documents, as compared maybe to a complex construction claim? So when you have, when you're looking at document production, then make it as easy as possible. And then issues of objections. I know by now everybody here knows that Section 2 of the Evidence Act says that the Evidence Act does not apply to arbitration matters. And whereas this may seem hard for people to digest, and especially Justice Mongo in Goodison 680 decision called them hard-boiled litigation lawyers who don't believe that actually you can do an arbitration from beginning to end without reference to the Evidence Act. So these things of people being served with documents, you go through all the pre-arbitration steps, and on the day of the hearing, instead of taking the witness through evidence, counsel or a party representative is raising objections and saying, we want the original to be produced by the maker. All those things in the Evidence Act. Do you need these rigors for document production in small claim arbitrations? Do you need expert evidence? Unless maybe for insurance, you're talking about a case of medical negligence. And even if it's medical negligence, the question here is not whether the doctor was negligent. We are saying that I had a valid cover, I have paid my premiums, there was an issue of medical negligence, I went to hospital, there was this, but what is the dispute? That I was in hospital and my insurance refused to pay for my treatment. Does that require an expert, or is it simply saying that the policy document provides that if I have paid my premiums and I suffer a particular kind of illness, then the insurance company will cover to the extent of my policy? So does that require an expert to come and produce and say the insurance company did not play its role? Written submissions. Do we always have to have written submissions that each party says I need 14 days, the other one says I need 14 days? Then the arbitrator will have to look at all those recent submissions and authorities to determine if this party should be refunded the 500,000 they paid as a deposit. Duplication of procedures, where you have you seen this case whereby an order for directions is issued, file your statement of claim together with the documents, then the other party will file a response and a counterclaim eventually together with their documents. Then the claimant will have a right to reply, file a reply to the defense and a defense to the counterclaim. Then the defendant will have a right to when does it end? And are we replicating too many procedures that are not necessary? So what is the practical test for procedure? And now we are assuming that now this is what is guiding the process. So the question to ask yourself, is this step genuinely necessary to grant fairness to the parties as required by Section 19 of the Arbitration Act? If the answer is yes, then proceed with that step, but keep it lean. Bare minimum steps to ensure fair hearing. There is no duplication or over padding of these processes. If the answer is a maybe, then if you are representing a party before an arbitrator, I know they are holding the pen and they will write the decision, but you have to be bold as a party or a party representative to challenge a procedure that you feel is not necessary or does not justify the cost. For instance, why would you go to do a site visit, all right, of an apartment? And this I have seen mostly even for works, because I do a lot of work in the construction space. You are a contractor who was doing a building, you handed over the building or you terminated for lack of payment, and for 3 years you've been trying to get your money. You do not know who came to complete the works, or if the works were completed and you've still not been paid, and another party is saying that there were defects that were never attended to. The defects liability period was 6 months or 1 year. And this is 3-4 years later. What will a site visit help with in determining whether you are entitled to payment? All right. There are people who will even say, going back to the same accident cases, there was an accident 3 years ago, the insurance company refused to pay. 3 years later, we are in arbitration. You may not even trace that car because it went to the insurance yard. And even if it's still there, is it in the same state it was 3 years ago? So how will going for a site visit to see that car help? So if a step may be necessary, but you see it is not cost effective, or it will not produce information that is relevant to determining the dispute, then challenge that and have the arbitrator make a determination. If the answer is that the step is not necessary, then refuse to have it in your arbitration and then exclude it completely, because this is a waste of time and resources. And remember that every minute that passes is an expense. So managing costs, then, my submission would be that managing costs in small claim arbitration starts from the drafting step. Therefore, you need to start controlling costs right from the beginning. If the clause that you drafted is vague, overcomplicated, etc., parties will end up fighting about the clause itself even before they now start the dispute. And this is why I usually encourage people that we don't teach arbitration so that you stop being a conveyancer if you're a lawyer, or you stop being a court-going lawyer, but we teach arbitration so that you can be a better party representative to your clients in the event they find themselves in an arbitration. So for the big law firms, we tell them, have your commercial team work with the disputes team. The commercial team will look at the commercial terms of the contract. The disputes team will end up looking at the dispute aspects of the contract in the case the marriage goes wrong. For those who are in what I hear younger practitioners calling OB law firms, whereby you are the receptionist, you're the senior partner, you are the associate, or you have an associate or a research assistant, then it behooves you to look at both the commercial and the dispute resolution aspects. And if you feel inadequate, call Kethi, call Peter, call that other person that you know to tell them, I am conversant with the commercial terms, but please give me some tips or pointers on the dispute resolution clause, so that you don't end up copy-pasting something that was meant for a $3 billion PPP project into a sale of land or a sale of an apartment clause. So be clear about appointment of arbitrators, the seat, the venue, the language, the applicable rules of the dispute, whether the case should be expedited. Don't leave these things to chance. It may take up an extra paragraph in the contract that you're drafting, but it will save you time and money in the event there was to be a dispute. Nowadays, we know the FDI from China to Africa has superseded what is coming from the West. So again, in the construction space, a lot of Chinese-based construction contracts are finding their way here, because what I have seen is that they're not adopting standard form contracts. They're tailor-making their own contract, which is also something very dangerous. Because if somebody was to take FIDIC or JBC and bastardize it, they end up sometimes removing clauses that were meant to protect both parties, or to protect the contractor, or to protect the employer. And now this making of what I hear some people calling a mongrel of a contract does away with some very important clauses that were meant for the protection of each of the parties. So take time to provide for everything that you think is necessary. Do you need hearing? Do you need to do it as a document only? Do you need a multi-tiered clause whereby you start with good faith negotiations? And in that period, like for example, if you look at clause 45 of the JBC contract, you find that it provides that yes, you can go to arbitration, but it says no arbitration shall commence unless parties have attempted good faith negotiations in a period of 90 days from when the period was, the dispute was notified. So these kind of cooling off periods are meant to help parties to have a conversation about resolving the dispute. Is it a dispute that must go to arbitration? And I know we are talking about arbitration. Have you considered making mediation a mandatory step? And if it doesn't work within 30 days or 60 days, go to adjudication or go to arbitration. Have you considered MEDAP as a clause in your contract? Now, for small claims then, coming back to my slide, is that ideally, if it is ideal for arbitration, then provide for a sole arbitrator for a dispute below a certain threshold. And this eliminates scheduling conflicts. I mean, if you have a 3-panel member like an exit arbitration, synchronizing of those diaries becomes a problem. It also reduces fees because you're paying one arbitrator, not 3 arbitrators, and also speed up proceedings. Imagine, for example, where you are challenging the tribunal and you have a 3-man or a 3-woman tribunal in a 10 million dispute. And then each member of the tribunal will have to apply their mind to the jurisdictional or challenge question that has been put before them. What is the effect of this on terms of course? Will the 3-person arbitral tribunal increase justice delivery? So these are questions that you need to ask yourself as you're drafting the clause. Can you be comfortable with a document-only option? Remember, some of these things may not be agreeable with parties when a dispute has arisen. So could you learn to have a bifurcation within your own arbitration clause whereby you say, if the issue is pure breach of contract and there are no technical issues, we shall do a documents only. If there are technical issues, then we will have expert witnesses. Those witnesses will be limited. They will not be a number that is not controllable. Can we, for example, agree to cap costs recoverable? You will notice that for very many years, ad hoc arbitration is based on hourly rates. But FCIArb, I think in 2024, if I'm not wrong, came up with a different mode of charging. You can do costs that are based on time, that is an hourly rate, or you can take a ballpark figure based on the value of subject matter and agree with parties that this is a claim for 1 million Kenya shillings. I will cap the total costs recoverable by the parties and the arbitrator to 500,000 work within that figure. So, or can you say, for example, if you're not sure of the figures, that the costs of these proceedings shall be capped to about 15 or 20% of the award or the amounts being claimed. All these are tools that you can use to manage costs. And as we are saying, it starts from the drafting stage. You don't have to wait for the dispute to crystallize for you now to start fighting with the other side on what procedural steps to take. One of the most problematic issues that usually arises is pathological clauses that then end up creating a dispute about the dispute instead of helping resolving the dispute. So ambiguity about the seat, about different languages. For example, just going back to the issue of Chinese FDI, do you then introduce into a small claim the issue of saying each party to bring their own interpreter? Because I am here as the arbitrator. I don't understand the Chinese language. Counsel or QS or architect representing one of the parties also only understands English and Swahili. The parties that are coming to represent these two entities are more conversant with Chinese, and in fact, most of their communication was in Chinese. So do they both get interpreters who come and for every sentence they say, somebody interprets for the arbitral tribunal and counsel or representatives, and then the other side disputes that interpretation, and then it becomes a problem. Could we then, for example, if there is such a contract that has different languages that are being used, to agree that in the event of a dispute, then those documents shall be interpreted by an entity that is already agreed on by the parties, and failing agreement that they would get an interpreter from the Chinese embassy in Kenya. So some of these things designate the language of the arbitration so that every other document should be interpreted. And if there is a dispute about how the interpretation has been done, who is going to give the neutral interpretation of these documents? The issue of seat and venue is a conversation that goes on for years, and both are very important. So always clearly designate the seat. Don't just say that because the procedural law has been chosen, it is automatic the seat will be at X place. So just put that one other line. The seat of this arbitration is Lusaka, it's Nairobi, without leaving it to chance, such that you start doing those proximity tests to determine what the parties intend. Again, you could be in a rush and say that we are being efficient, such that we say that an award shall be issued within 30 days of close of pleadings or submissions. So when again you put impossible deadlines, and remember, courts have said time and again that their work is not to redraft contracts for the parties. They enforce what you have agreed. So now you have one that says 30 days for making of the award. Is it practically possible? All right. Even it's a small claim, yes, somebody might say 30 days from the final submissions, it's possible. But have you factored in other challenges? And is this cast in stone such that the arbitrator has no leeway to extend the time, and the rules do not provide for extension of time? So whereas we are looking at expediency, it should not be at any cost. That then makes it impossible for parties to get what they wanted. Define the appointing authority. I have seen these clauses where it just simply says that in the event of a dispute, it shall be taken to arbitration, and the arbitrator will render a final award. Parties are to agree on the arbitrator, and it ends there. What happens if they don't agree on an arbitrator? Where do they go? Sometimes I've seen people going to court to ask the court to appoint an arbitrator. We have conversations with courts on how to go with this, but there are courts that will say, Section 10 says I can only intervene in accordance with that. An appointing of an arbitrator is not one of the roles that have been given. Others will say, yes, we have looked at the act, and there is somewhere the High Court is mentioned. And this is in the event that an arbitrator is removed, replacement can be done by court, etc. So the act is not very clear on default appointments, because you'll again find this more in procedural rules. So define that parties will agree, and if they can't agree, who is this default appointing authority? And please, 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 when you're putting a default appointing authority, one, be clear in the name of that authority. We have Architectural Association of Kenya. There is no Kenyan architectural whatever. So get the name right. Secondly, if you're saying the appointing authority will be the London Court of International Arbitration, or the registrar of the ICC, or the president of the ICC court, or they use the rules will be ICC rules, do you know what you're putting your client into? All right. So be very careful when you're doing this and avoid such types of clauses. I know Peter had said if there's time, we'll look at a model clause. Go to the FCIArb rules. The first schedule of the FCIArb Kenya arbitration rules.
To disrupt you,
yes,
we could share this at the end. We've had I think it's more suitable to discuss the model framework clause at the end of the presentation of the webinar.
Right.
Sorry, if you don't mind.
All right. Yes, that's fine. Now about small claims, efficiency versus fairness. All right. Speed and proportionality are preconditions for fairness in small claims. So it is not one at the expense of the other. Speed at the expense of proportionality, or proportionality, and then you end up taking forever to do this. So you've seen cases where claimants abandon valid claims because it's becoming too expensive to pursue the claim. Respondents settling under cost pressure because they're saying, have you had a situation, and maybe Peter as the moderator will tell us later, one of the things of being, what do you call it? These, when you begin practice, deposit, parties pay the deposit, you continue, they bring objections to this, you write a ruling, they bring objection to that, you write a ruling, and then one day you wake up and realize that you've been spending time and not billing for it. So you sit down and calculate the time that you've taken in all these interlocutory applications that you've been determining. And then you tell the parties, by the way, we are heading to hearing, but before the hearing, there's this bill, please settle it. Then they go quiet and disappear. Sometimes you find parties go and settle, negotiate, settle the matter, and you're left calling them to come back. Nobody to pay for your hours. And sometimes even respondents settling under the pressure of cost and saying, if this claim was for 500,000 and by now we have not begun hearing and the arbitrator is asking for 300, I think I'd rather persuade the other party to accept some amount and we settle. Is that justice? Maybe, maybe not. So arbitration as a process, and this is a conversation even at the peers lounge that happens. Are we losing connection? Are we losing touch? Are we losing the reason why arbitration was put in the first place as a means of resolving commercial disputes? If you look at Section 20, subsection 2 of the Arbitration Act, one says parties are free to agree on the procedure. Then subsection 2 says that in the event parties do not agree on the procedure, then the arbitral tribunal is free to decide on a procedure that allows for fairness, but also expedited proceedings to reduce on costs and expenses of the arbitration. So whereas again we say under Section 19, Article 50 of the Constitution, because now it comes into place sometimes about fair hearing, the question is, have I given these parties a fair opportunity to present their case? So if we have a party who continually causes adjournments at the last minute, and even after finding them and other things, they're not still proceedings, are you still giving a fair hearing to the parties by delaying the proceeding? So it is not in every case that you issue peremptory order number 1, peremptory order number 2 on the same issue. It gets to a point that you have to be bold enough to say, Section 26 allows me to proceed in your absence, and I'm proceeding. So there must be a balance between efficiency and fairness in the process. Now, FCIArb does ad hoc arbitrations. We don't administer. So again, some question to consider. At times, would you maybe think that institutional support could be important to some arbitrations, especially maybe depending on the subject matter, the parties involved, etc., etc. What you will note from all institutional arbitrations, they define costs that are to be incurred in the arbitration. If you look at ICC, it gets a graduated scale depending on the value of the subject matter. Same for NCIA, they provide for a graduated scale. But in particular for NCIA, when you look at domestic arbitration, it caps the cost of the arbitrator to not more than 25,000 Kenya shillings per hour. And it also gives the registrar power to set the hourly rate. It also ring fences you from fighting with the parties. You are the decision maker, but at the same time, you're fighting with parties to pay your bills. Institutional arbitrations introduce a third person who could be the case manager or the case management department to run the procedural steps like scheduling of dates, collection of deposits, and these deposits are then released to the arbitrator depending on the progress of the case. So you can see that even our own act, the Arbitration Act, talks about cost effectiveness. It has not gone ahead to provide for that, but in our 2020 rules, there are provisions that have been input to ensure that arbitral costs are effective. So in closing, Peter, this segment of this conversation, a good clause should be designed to be to guarantee efficiency and also to guarantee keeping costs low for the parties. Otherwise, it will not make sense for parties to come to arbitration and they are already having disputes even before they start arbitration proper. It also preserves confidence in arbitration as an accessible remedy to parties seeking to resolve a commercial or a civil dispute other than going to court. And then design each clause for the dispute that is envisaged by the parties. If you're doing a sale of an apartment, how many things can go wrong? And limit the clause to those possibilities so that you know, is mediation suitable, is arbitration suitable, not just copy pasting clauses from precedents that are given by the parties. Thank you very much. I'll leave it now to Kethi to handle the other portion, then we can take questions. Or
Thank
Peter
you.
will have to take questions first.
Yeah, thank you very much, Sam. I think we'll take questions after. You've gone at great length to discuss the drafting aspect of the clauses, which is very helpful, especially from an advocate's perspective, that is a person drafting the clause. But given that a good number of us, members of the Chartered Institute, interact with these clauses at the point where we are appointed to preside over the dispute, how do we then manage the cost during the process of the arbitration? I think Kethi will share her views where we've already been appointed as an arbitrator. The clause is already there, been appointed properly, but the parties are before you. It's not a big claim. Maybe you're a fellow, you're required to charge according to a certain scale. How do we go about it to help parties feel comfortable enough to go through the arbitration without feeling exploited by the arbitrator? Because I think there's a growing challenge of arbitrators charging a lot more, as you said, some more, at times more than what the claim is, or maybe up to 70-80% of the value of the claim. The claim is for 5 million. You get the arbitrator's cost going to way over 1 million, 1.5. Is that fair to the parties? Is that an efficient way of managing the process? How do we go about it? So as Kethi presents, also be thinking of about some of the experiences and tidbits that you can share with regard to that. So Kethi, are you there?
Yeah, and as Kethi comes in, Peter,
yeah.
In these party-appointed arbitrations, even FCIArb appointed arbitrations, I've had opportunities where I have asked parties, is this practicable? I know you're coming at the stage of the dispute. This was done 5 years ago before you even became aware. But now you're here before me and you've realized it says LCIA, ICC, and it's a small claim. Is it practicable? And parties have gone ahead and entered into a post-dispute arbitration clause guided by the tribunal that is more workable. And I would encourage both party representatives and arbitrators to be bold enough to ask parties, yes, you're here before me, but is this practicable? And now by the time they've appointed you, you even tell them, I can't take jurisdiction because LCIA has to confirm my appointment. Is that what you intended? And parties, because they are present, have gone and agreed and come back with a clause that says arbitration in Nairobi using FCIArb rules. So it is doable instead of dealing with an absurdity and getting an award set aside.
So basically redrafting the clause post the dispute. I think you'll share with us some of those experiences. Kethi?
I'm here.
Okay, I thought you had disappeared on us. So the floor is yours. Share your experiences and what you think we can do to manage and control the costs. We'll take the questions after for both Kethi's presentation and Sam's presentation. So I encourage the members to start typing out any question that you have. Even if it's a question that is not directly related to the presentation, I think we have enough experience to respond to most of the questions. Thank you very much, Kethi. Take us through yours.
Thank you, Peter. Am I an experienced arbitrator? I'll put a question mark on that. My name is Kethi Kilinzo. I am a practicing arbitrator, and I am extremely well trained by the Chartered Institute of Arbitrators in the practice of arbitration. In my presentation today, I'll concentrate more on our role as arbitrators. I'm sure many of the participants today are advocates, but that is for another day. I'll speak to how, as an arbitral tribunal, whether you're sitting as a sole arbitrator or part of a panel, you can manage costs, and especially in small arbitration claims. I'll not define what arbitration costs mean, but I will reference in this presentation the Chartered Institute of Arbitrators Kenya Branch Rules of 2020 and the Arbitration Act of 1995. The reason this presentation will concentrate more on the Chartered Institute of Arbitrator rules is because it gives tools to arbitrators to manage costs in small claims, in larger claims, and even when arbitrators are sitting in a panel. The question to participants today is, are you aware of the rules? Are you aware of the provisions that deal with small claims in arbitrations? Are you aware that there are provisions for expedited procedures? And I'll go through this briefly. The other question I will ask to participants today, and my fellow presenter has dwelt heavily on this issue. When you're drafting your arbitration clauses and you're a member of the Chartered Institute of Arbitrators, do you include the arbitration rules? And if you don't, why? What is the reason why you exclude them? As an arbitrator, when you're in charge of arbitral proceedings and the arbitration clause does not provide for the Chartered Institute of Arbitrators Kenya branch rules, do you ask the parties to consider to adopt them? And if not, why? I'll give you reasons why it is important to consider these rules when you're drafting the arbitration clause as an advocate and as an arbitral tribunal, to ask parties to adopt them. Mr. Nderitu had mentioned that there is no definition of a small claim in arbitration. Rule 77 through the back door attempts to define what a small claim would be by making a cap of 10 million where the parties choose to use a fast track procedure. That is under Rule 77. The 10 million excludes interest, it includes party-to-party costs, it excludes legal costs, and it also excludes the arbitral arbitral tribunals' fees and its costs. The 10 million includes the claim and the counterclaim, or if there's any defense of set-off. Perhaps this is the time the Chartered Institute of Arbitrators, Kenya branch, should consider whether they should increase this limit to 25 million to match the limit for magistrates court, so that it can allow parties to then adopt the rules that allow for arbitral proceedings to be determined, heard and determined in a more expedited manner. When I'm speaking about the rules, I'll try as much as possible to draw your attention to the cost element. I think it starts at Rule 5. Under Rule 5, the advocates or the parties are given the procedure through which they can request the Chartered Institute of Arbitrators to appoint an arbitrator. The request must be in writing. It must specify the party details. It must include the arbitration clause. It must include the dispute summary, the remedies, and the supporting documents. This is important for purposes of cost because it starts to put a border around the dispute. What is the dispute? What is the party going to claim? The Institute is required within 14 days of receipt of that request to appoint an arbitrator. There seems to be a conflict in the rules because Rule 6 gives the respondent the right to address the Institute on the request for the appointment of the arbitrator. They have a right to confirm or deny the claims, to give a brief statement of the nature of the circumstances, and if they will be filing a counterclaim. And the respondent is required to do so within 14 days. It's important that the respondent has an opportunity to put a response, but it is also more important that there should be a time limit or a time gap between when the respondent can put in their response and when the Institute appoints the arbitrator. By providing the arbitration clause to the Institute, then it limits arguments later about whether the nomination has been properly done, whether the Chartered Institute is a proper appointing authority, and it reduces communication on the process of nomination. I'd like to pause here and ask the participants, as members of the Institute, when we are nominated by the Institute to take an arbitration, do we stop to ask the question whether we are qualified to do so? I'll go back and borrow this paragraph from Ringera's decision in First American Bank of Kenya Limited versus Gulab Shah and others, where in taxing a bill of costs, he said an advocate should not say that they did extensive research because they are required to know the law. By the time they're taking up a matter, they can't use unfamiliarity with the matter or the law as a basis for their costs. Advocates should not learn at the expense of their clients. The same should be for arbitrators. Arbitral tribunals should not learn or gain experience at the cost of the parties. If an arbitral tribunal has the requisite qualification and the experience required for the dispute, it will be possessed with the relevant tools to effectively and efficiently determine the dispute. By asking yourself the question, is this within my remit of qualification? Is this within my remit of experience? Then you prevent jurisdictional challenges before you and the courts. You also prevent appeals. You prevent appeals from your award, because if you have experience and qualification, you're less likely to make errors of law or fact. You're also more likely to determine the dispute in a faster way with efficiency, because you don't need to go and research. When the parties are presenting evidence and the law before you, since you have the experience and qualification, you will be able to call the bluff when parties are trying to test whether you have the knowledge, whether you have the expertise, whether you have the qualification. Rule 8 is also important in terms of costs, because under Rule 8, the arbitration proceedings are presumed to start or to commence on the date the respondent receives the request to refer the dispute to arbitration. This is a request I earlier referenced under Rule 5. This ties the commencement of the arbitration proceedings to an event, and it reduces the costs that are associated with parties arguing about limitation of time and procedural aspects. I am sure that all of us, if not all of us, many of us know that once you make the request for appointment, the Chartered Institute of Arbitrators will request for a fee of 20,000, which is a recoverable cost. As my fellow presenter mentioned, the structure of the tribunal is a key driver of the cost of the arbitral proceedings. The costs of a 3-member tribunal and the cost of a sole arbitrator will be extremely different. The speed at which a 3-member arbitration and a sole arbitration will take place are extremely different. And again, as my co-presenter mentioned, this goes back to the point at which you are drafting your clause. I'll stop there and again pose a challenge. Many times when you're drafting the arbitration clause, the qualification and experience of the arbitral tribunal is important. Some clauses will require an advocate of 15 years standing. Others might request for an architect or an engineer. Have we ever stopped to think about the costs in drafting that clause? What stops advocates? What stops you from indicating the experience of the tribunal in arbitral matters? Because that has a cost element. If the chairman of the institute appoints a member of the institute who has 20 years plus in experience in handling arbitration matters, the costs will be different than an associate who has 3 years or 5 years experience. Some disputes do not need a member with vast experience. That is something I believe we should think about, and something that occurred to me as I was preparing for today's presentation. Let's demarcate the experience of the arbitral tribunal as well as the experience of the arbitrator in handling arbitration matters, especially if it is within the Chartered Institute of Arbitrators, Kenya branch. The expenses of a tribunal, which are different from the arbitral fees, is a matter that both advocates and arbitrators play a role. As an arbitral tribunal, whether the hearing is virtual or physical, whether the hearing will be conducted for one day or over several days, whether the hearing will be staggered, maybe in April and in May, has a bearing on the cost. And my fellow co-presenter mentioned that matter, and it's something that ought to be considered. The arbitral tribunal is a master of procedure. As some mentioned about Section 20 of the Arbitration Act, and it's also in the rules. It is not the, yes, arbitration is party-driven, but the arbitrator has more tools than a court of law to dictate how the process of the arbitration should go. One of the tools is awarding costs. The general rule is costs follow the event. If you have a party whose advocates conduct themselves in such a way that the arbitration is delayed or takes a longer time, you as the arbitrator have the power to determine what costs should be awarded to the other party if they are the successful party, or what costs should not be awarded to that particular party that delayed the proceedings. Those are tools that are within the arbitral tribunal's powers. I'll go to some of the methods in which the rules have given arbitrators the tools to expedite the proceedings. Some had mentioned this, and I had as well when I was starting my presentation. Under Rule 77 to 87, fast-track procedure is provided for claims that are below Kenya shillings 10 million. As I said earlier, that includes the counterclaim or set-off, if there's any, and excludes interest and costs of the parties and the arbitral tribunal. Under the fast-track procedure, there can only be a sole arbitrator. The decision to use this procedure is made by the party when they are requesting for the nomination of an arbitrator. If a sole arbitrator is appointed under the fast-track procedure, they must convene a status hearing within 7 days of their appointment. And at that status hearing, they set the timeline for filing of pleadings. The claimant has 7 days. The respondent will have 7 days to respond after service with the response and or the counterclaim. And after those 7 days, the claimant then can file their reply or defense and counterclaim. The pleadings close within 7 days after the last reply, and the hearing, which should be for 1 day only, must be convened within 14 days of the close of the pleadings. Under the rules, as the arbitrator, within 30 days of the close of the pleadings, you must publish your award. This procedure relies on disciplined compliance by the arbitrator as a master of proceedings and by the parties. The rules may be varied, they may be extended, but this should be on exceptional basis and when it is necessary. It is important to note that under the rules, where you conduct your proceedings as an arbitrator under the fast track procedure, as mentioned, you have 30 days to publish your award after the hearings. Where it is a documents-only arbitration, under Rules 74 to 76, you are required to publish your award within 2 months of the close of pleadings. The documents-only arbitration procedure, it is party-driven. It cannot be imposed by the arbitral tribunal if it is not agreed to by both parties. And the arbitration proceeds on the basis of documentary evidence only. It is important to concede that the rules could be more explicit on this procedure. It is also important to note that if as an arbitrator you consider that a full formal hearing is required, then you advise the parties of this alternative way or mode of the arbitration proceedings. For arbitrations that are conducted after oral hearing, those that are not fast-tracked or are not documents only, as an arbitral tribunal under the rules, you are required to deliver your award within 90 days after the hearing. That is under Rule 115. And you must notify the Chartered Institute of Arbitrators. If you are unable for any reason to publish your awards within the 30 days, if it is fast track, 60 days if it's documents only, 90 days if it is proceedings by way of oral hearing. And this is why I like these rules, to apply them and to apply them in the proceedings, because they put you in a straitjacket. The beauty of proceedings that are conducted in an expedited manner and within the rules is that parties are then offered services that are cost effective. There's the element of interest. If there's interest within the time, if there's interest accruing within the time you're conducting the proceedings, the faster you conclude the proceedings, the less interest the party who is unsuccessful will have to pay. The less time you conduct in your proceedings, the more cost effective it will be, because you will charge the parties less if it is based on the time you have spent in conducting the proceedings. The rules provide for virtual and hybrid proceedings. You as the arbitrator, you can, if the parties agree, conduct the proceedings, the entire proceedings virtually or part of it. If you're having pre-trial conference meetings or you're having other meetings with the party, there's no reason why virtual proceedings cannot be adopted. And this are both cost and time effective. I'll speak to just a few more matters as you're squinting, trying to see what is in the last screen. Yes, it is the last screen.
About to say we can't see anything on that screen, but carry on.
Yes, it's deliberate as everyone is trying to squint and see what is written. I wanted to just mention a few matters that will assist parties in reducing the time spent in arbitral proceedings. The rules provide for interim measures. This is more important for advocates, but it's also important for arbitrators. You do not have to go to the courts to seek interim measures. If you look at the rules from Rule 35 to Rule 44, the arbitral tribunal, if it's conducting its proceedings under the rules, has many tools and can even give more drastic interim measures than you'd get from the court of law. It's important for the advocates, for the parties to know that. For the arbitral tribunal, it's an important tool. You can mention to the parties, if they allow you to conduct the proceedings under the rules, you can then give them these interim measures and they do not have to go to court. Section 32B allows the arbitral tribunal to tax costs. Again, this is a cost-saving measure because then parties do not have to go to court to have their party-to-party cost taxed. Peter, that will mark the end of my presentation.
Well, thank you very much for that very detailed presentation. And I think we'll have to share the slides with the members or the participants who have attended to enable them reflect further on the presentation. So maybe before we deal with the questions, I've just seen one question from someone asking, kindly explain how an arbitrator is to access. I think they mean assess cost where parties in their submissions don't quantify their cost, but leave it to the arbitrator. As Kethi has said, as an arbitrator or as an arbitral tribunal, Section 32B gives you full discretion to determine the cost of the arbitration. And one of the ways you can do that is assessing the cost as per the ARO. I know there's no specific scale that is exclusive for arbitration proceedings, but I think the conventional practice is to apply the ARO, which serves as a very good objective standard for reasonableness. So to answer your question, if the parties have not quantified their cost and they leave it to you, one efficient way to go about it is to ask them to submit their, what we call the bills of cost, and then you can assess that and make an additional award. I don't know what your views are, Sam, with regard to that question, as I look at the other questions that are coming in. I also ask the participants to type out the questions as we carry on.
Yes, thank you very much, Peter. I think you've captured it. Just to add that it is one of those bad habits that parties have brought from litigation, where we leave it to the court. You don't want to say anything, you leave it to the court. But you see, in as much as Section 32B gives the arbitral tribunal power to determine and apportion costs. Remember the definition in the same section of costs of the arbitration. It includes the legal and other expenses of the parties. So whereas you correctly state, if you look at Rule 10 of the arbitration rules made by the Chief Justice that are attached to the Arbitration Act, Rule 10 says that our proceedings under the Act, meaning the Arbitration Act, the cost shall be assessed in the same manner as the cost of a high court. And there are so many other decisions that have been churned out, even by the Court of Appeal on this issue. So it is settled that until there is a schedule provided for how you tax costs in arbitrations, and I know you have worked on that under the new ARO that is being discussed by members of Law Society, then you have the ARO to guide you in assessing the legal cost. But legal cost is just one portion. What of other expenses? If parties had to pay witnesses, you paid a QS to come and support your arbitration. Somebody had to fly from out of jurisdiction, stay in a hotel for several days. How do you quantify those other costs? So what I've always done is tell parties that if they had not submitted on that and you've done the award on merit, save as to cost, you can ask them for submission strictly on the issue of cost, and you make an additional award under Section 34, which is allowed. If you still do that and they refuse to give the cost and they say they leave it to me, I assess the legal costs because I have no any other way of knowing what are the costs that they could have incurred. And even in assessing legal costs, such things, is it fit for counsel, for example, for a small claim arbitration, for you to claim that you needed 2 lawyers to represent you, and therefore you are claiming fees, instruction fees for 2 advocates from 2 separate firms. So proportionality and reasonableness still come into play. But if you are a party representative, please put in the submissions to help the arbitrator determine the costs. On the other hand, if you are arbitrator, don't shy away from giving directions on parties as you give at the close of the hearing. You can tell them, as you write your submissions on the merits of the case, do also give me submissions on costs of the case, so that we deal with it together. But even if you have awarded them the award, I can still ask for submissions to make an additional award.
In fact, what I normally do, as you've said, at the time you've closed the hearing and you're giving directions of the written submissions, you insist that parties must address you on the cost, including possibly filing their bills of cost, which then compute the party and party cost. There's a question that has come in, and I think I'll ask you some before we take the rest for Kethi. In your experience, how can tribunals strike a practical balance between respecting party autonomy and actively intervening to prevent procedural excesses in small claims arbitration, particularly where parties themselves are driving disproportionate steps?
All right, thank you very much for that question. I will still go back to the tribunal's duty under Section 22. The duty of conducting the proceedings in a manner that avoids unnecessary delay and expenses, while still giving parties an opportunity to present their case. So sometimes, being the arbitrator, if parties are saying, we want to do written submissions on that issue, do you know, even filing a notice of motion, why are you filing a notice of motion complete with affidavits and annexures for a small issue that you can write an email, I ask the other party to respond, and I make a determination? Sometimes there are even issues we make determinations on the spot after hearing both parties. So do we have to file this notice of motion? So there are times people say, even a small issue like filing an additional document, somebody is saying that I noticed that I filed the contract that was just signed by one party, and I note that this other one. Then another one saying, I am objecting to filing of additional documents, and it is still at the early stages, we've not even gone for hearing. Then I will tell somebody, let me know why you need to have that document on record, and the other one, respond to that email or letter and let me know why you're objecting to it. So these people who go and say, I want to file a formal application. What is a formal application? Another bad habit that we've borrowed from Evidence Act and courts. Do you need a notice of motion and then a replying affidavit and a further affidavit just to decide, can we have this other document that was actually signed by both parties? So it calls to firmness of arbitrators to know that, as Kethi said, you are the master of procedure. And there are so many decisions, all the way to Supreme Court. Njeru and all the others have confirmed the arbitrator is the master of procedure. So if I see you are doing what is anti-arbitration, I will ask you whether it is necessary. And if you disregard my caution, then I will proceed with that unnecessary step and I will bill you for the hours that I spent. Even people who come and object and say, Evidence Act Section 87 document must be original by the maker, and you're raising it at the hearing when we have gone through discoveries, interrogatories, and everything. And I ask you, do you still want to go ahead with that challenge? And they say, I want to put it in writing. I usually do a very short ruling, citing Section 2 and saying, if you had objected, you remember also the Act says, if you knew something that was objectionable, you lost the right to object when you never raised it in good time. So these delaying tactics or delaying tactics come at a cost to the party that is messing around. If it is both that are doing these things, sometimes it's out of not knowing. And I guide them on the process and say, the act, the rules say this, why are we going down that route? So it's about the arbitrator being firm while being fair to the parties.
All right, thank you very much. So we should always remember that the arbitrator is in charge of the proceedings. Kethi, there's a question to you. Madam Kethi has mentioned that some cases do not need arbitrators with vast experience. Kindly expound, clarify on this. When you say that some matters do not require people with experience.
Okay. Perhaps I could have put it more elegantly. I'll refer to the Chartered Institute of Arbitrators. As you're moving through the ranks of the Chartered Institute of Arbitrators, from associate to member to fellow and chartered arbitrators, and as you're studying for and passing the various assessments, the scale of fees you can charge per hour are different. This speaks to your experience as an arbitrator, your qualifications as an arbitrator. So if you have a dispute, at the end of the day, it is about the subject matter of a dispute. If you have a dispute that an associate member of the Chartered Institute of Arbitrators with, say, 5 to 7 years experience under the institute can resolve, it will cost less to the parties for that matter to be referred to such a member than if it is referred to a chartered arbitrator, who in most cases have 25 or more years of experience in arbitration. So that is what I said. As I was preparing for this presentation, it actually occurred to me that one, you can choose the qualification of the arbitrator. Do you want an architect? Do you want an advocate? Do you want an engineer? If it is an architect, do you want an architect who has experience of 15 years? That is a different expertise from the experience of you're an associate member of the institute, and therefore you maybe have 3 to 5 years, and you're an architect of 15 years standing, and also a chartered arbitrator. The costs of a chartered arbitrator and a member of the Chartered Institute of Arbitrator are different, as is the experience and their qualifications, and even the way the proceedings will be conducted. I hope that answers the question.
I hope so. I just would to interrupt a bit. I've seen Professor Wine Mutuma, the Chartered Institute's chair, has joined. Prof, can you hear?
Yes, I can hear, Director. Thank you very much for the excellent moderation.
Thank you very much. We pray and hope and believe that you have something important to tell us, to share in relation to this webinar. So we'll give you some time to greet us and tell us and share your insights, in as much as you're not a speaker.
Thank you very much. I want to first say to my wonderful colleagues, Emeritus and Kethi, I've really enjoyed listening to this session very, very much, and the attention to detail that you have given. You can see flowing from the questions. Usually, as a Mwalimu, we know that the more interactive a session is, it means the class was wide awake and they were enjoying what they were hearing. So I wanted to say thank you very much for that. And then I wanted to throw a policy consideration on the back of what Kethi you've just said in just shortly. You have talked about costs, and of course we are in the small claims domain. That I think what's happening from an institutional point of view can weigh in, because when we were coming up with the 2020 rules, this was what we had in mind. Kenya is an informal and an SME economy predominantly. And there is a lot of contracts and transactions happening at that scale. Low value, but extremely numerous in number. And we are engaged in a conversation with the Chamber of Commerce, the KNCC, and the judiciary, small claims.
I think we've lost the.
That is specifically Susan Mangeni, on how we can generate enough practitioners to create a fast-track arbitration system at relatively low costs for the thousands of small claims that are rising. I think, Emeritus, when you are on the driver's seat and you are coming up with those provisions during the COVID time, this must have been on the mind of quite a number of the team that you worked with in charting out the rules. So I just wanted to throw the minds of the panelists, Moderator, to that discussion. It is very, very beneficial because it will create a huge amount of work for our members. And I know we will need 5,000 or so matters coming to fast-track arbitration. What that means for us is the capacity gap must be filled. So it's an open-ended reflection. I hope, Emeritus, that you can weigh in on that discussion, given the role that you played in the creation of the. We can also, at the same time, this is the problem of when you're using a device and people are calling and they keep interrupting what you're trying to say. So I'll leave it open-ended and once again say thank you very much, Moderator, Director Peter Njeru, and to the panelists. I would be very keen to hear some of your thoughts along those lines. Asante sana.
Thank you very much, Chair. And I'll ask Sam Nderitu whether you have any immediate reaction to that, or you need to think, to put your thoughts together on that. But based on your experience and the fact that you're involved in the generation and formulation of the regulations, what do you have to say about that? Then we'll carry on with the questions. I can see we have some additional questions. So maybe you can react to that. And then the next question, I'll also put it to you once you've reacted.
Maybe, Peter, I can have time to think. The background to the 2020 rules is that we had rules of, I think they were more than 20 years old. We had rules of 2002. And when we were working with those rules, we were looking at best practice, but also try to address to our minds about efficiency and things like that. Sometimes it's not possible to know what nature of claims will come before you. And as I was saying earlier, I have not seen, the same way Kethi was saying, the rules introduced through the back door. There is not a single rule that I've seen classifying this as small claim arbitrations, and therefore we need to deal with them in this matter. Again, there is the danger of classifying something as small claim just because the monetary aspect is very small, but the legal or technical issues are very convoluted. So my immediate thought is that we need years to keep looking at our rules and seeing how do we need to improve them. They've been serving us for the last 5 or so years. We can look at what improvements can be made, but also looking at, did we get something wrong? How can we amend it? Or did we get something right, but we need to refine it better? I think that is what I would say about the rules. I didn't catch most of the conversation, the question. I think also my internet was fluctuating on this end, but I
Okay.
can engage on this further.
All right. So maybe even to move on, Akech Elvira is asking, what is the best way to appoint an arbitrator if parties have not selected an arbitral institution, but the arbitral clause makes reference to the Arbitration Act of 1995? Essentially, is the High Court the only resort if parties do not agree on the appointment of the arbitrator in such a case?
The thing is, as I've said, if you look at decisions post 2010 Constitution, it was very difficult to even convince the court to appoint that arbitrator, because if you look at appointment, the particular section of the Act that deals with appointment of arbitrator leaves it to the parties to agree on the arbitrator and talks more of if one is to be appointed, parties are to agree. If 2 or 3 are to be appointed. So it makes such provisions, but then does not talk about what happens in case of default. So what I've seen is mostly people citing Article 159, asking the court to support the decision that parties had made to go to arbitration in the event of a dispute. And courts relying on Article 159 have been able to appoint arbitrators. But if you go strictly with the Act, it becomes a problem. The only part that you find about appointment of an arbitrator is when there is a challenge to an arbitrator and the arbitrator makes a decision and then the High Court goes ahead and decides on that issue. Then you find that in some aspect, people have gone and told the court, if you remove the arbitrator, we're also praying that you give us a replacement instead of going back to square zero. But for first-time appointments, it becomes very messy if you do not agree on an arbitrator, and 2, you do not provide a default authority. So what I have seen is people now going to court, invoking the Constitution, which is the supreme law, saying that court, you're supposed to support arbitration, and we had intended to go to arbitration, therefore appoint for us. In some other instances, post 2010, and even when we were still testing the Constitution, some courts have held that that clause has become inoperable because there is no provision. If parties do not agree, what happens? So they say that that clause has become inoperable, but the remedies for the aggrieved parties are not taken away because they can go to any other legal forum. So sometimes those matters ended up in court, but I have seen cases where now courts and parties are using Article 159 to get the appointment, which now goes back to where we started, drafting of these clauses.
Thank you very much. Nothing to add to that. Kethi, there's a question here. So from experience, how effective is a 3-tier dispute resolution where mediation is involved, especially where parties absolutely do not agree during good faith negotiations? Is it more efficient to pursue mediation or to go straight to arbitration? Second, how do you deal with parties who refuse to pay the initial cost of the tribunal, especially where it is likely to be used as a delaying tactic?
Okay. I'll take the reference to 3-tier as referring to, one, the parties trying to negotiate between themselves to resolve a dispute. Then when they fail to do so, to go to mediation. And then finally, if mediation fails, they go to arbitration. The best solution is always the one that is agreed by the parties, either through parties negotiating to resolve the dispute or through mediation. Mediation has many benefits. It's the foremost benefit is it is party-driven. So if the subject matter of the dispute allows, I would encourage that in drafting the alternative dispute resolution clause, that you allow parties first to negotiate amongst themselves, to go for mediation, and then if that fails, to go for arbitration. Just like the experience of an arbitrator is important, the experience of a mediator is also important. I am a very big fan of the Chartered Institute of Arbitrators, as you can tell. I think their training is excellent, not only for arbitrators, but also for mediators. So if you are drafting the mediation clause, I would encourage you to put the Chartered Institute of Arbitrators as the appointing authority for the mediator, and then also specify, do you want a mediator who has a qualification in a particular area, or do you want a mediator who has experience in mediation, or who has just started or is in the middle tier? That will have an effect on the cost of the mediation. The more experienced the mediator, like an arbitrator, the more costly the mediation process will be. Fortunately, if you go before an experienced mediator, they'll be able to tell very quickly if there's a party who is not in the mediation process in good faith and who is unlikely to resolve the dispute through mediation. And they will be able to put it to an end to allow the parties to follow the other process. Is it important? Yes. Thank you, Peter. It seems
for Peter. Oh, he's here.
Speaking to myself. There's another part of that question. How do you deal with parties who refuse to pay the initial cost of the tribunal, especially where it is likely to be used as a delaying tactic? I think basically where one of the parties refuses to pay your deposit as an arbitrator. How do you deal with it, Sam?
Well, the thing is that the arbitrator has to be paid. And if you look at section 32, again, parties are jointly and severally liable for the arbitrator's cost. I know we go by way of taking deposits from either side. And the fact that one of the parties has not paid their portion does not take away the duty of the parties to pay the arbitrator. So as it always happened, it's the party that is interested in the outcome of the process who sometimes, unfortunately, bears the burden of financing the arbitration. And being alive to that fact is why the current amendments that have been proposed to the Attorney General to the Arbitration Act is to allow for that party funding to take away the sting, or rather the burden of a party. For example, you are owed 300 million by the government of Kenya for doing a building of a road or a building, and now you're expected now to also pay for the arbitrator. So that party funding is a good answer, but the bottom line is, since the tribunal must be paid, then if they're not paid, they'll down their tools. So it is the party who really needs the process to go through to get paid. An arbitrator can issue peremptory orders under section 26, telling the party to pay. But remember also, you're told, even if they refuse to pay, the only sanctions you can do is that, again, going back to fair hearing, will you tell them that we will not hear your defense because you have not paid the fees? So it's a very challenging situation, and eventually what you see is the party that wants the arbitration to proceed is left bearing the burden of paying the fees. And then if they are successful, they can be granted costs which they can recover, but it's a dicey situation which is managed on a case-by-case basis. But bottom line, the arbitrator has been paid for the proceedings to go on. And maybe just before you come in, I thought I would clarify the first question about appointment. The sole arbitrator issue is the one that is tricky, but when you go now to appointment of more than one arbitrator, where each party is to appoint an arbitrator, and one party appoints, the other one refuses to appoint or does not respond, then the one who has appointed can write to the other party, notifying them that they have nominated their appointee as the sole arbitrator. And if there is no objection, I think it's within of 14 or 21 days, then that appointment becomes final. If on the other hand, that other party goes to challenge it in court and shows the court there was a reason for not being able to appoint, then the court can set aside that appointment. Now, in setting aside, that section talks of something interesting. It says that the court, on the application of either party or by consent of either parties, can appoint a sole arbitrator. So that is the only scenario in the Act envisaged where the court can appoint a sole arbitrator. If the parties apply in the instance where there were to be two and one has not appointed, or the parties consent that since now we are here in court, instead of starting the appointment process again, court can you appoint? So that is the only scenario. But for a sole arbitrator, there is a problem, and that's why people go to 159 and marry it with a bit of 16 to say, you see, court can appoint. So even if it is not directly said for the sole arbitrator, it is unfair that court can only appoint where there are to be two or three, but for sole it can't appoint if there is default. Some have succeeded, some have not. I'm yet to see a binding authority, maybe a decision. I've seen varying decisions of High Court, but I've not seen like now Court of Appeal determining this issue with finality. So please do proper drafting.
All right, thank you very much. Maybe to add to the issue of getting paid by the parties, as an arbitrator, you should always remind the parties that throughout the proceedings, they remain jointly and severally liable for the arbitrator's costs, so that either party can pay. And also ensure that you get a deposit. Once you get it, then get things going as the proceedings carry on. You can weigh and see whether you require further deposits. If not, you can just wait until the time of publishing the award. And as some have said, usually from experience, the claimant is the one who is very much interested in the outcome, and more often than not, they foot the initial costs and including the cost throughout the proceedings. There's another question from Kethi. From a regulatory or professional standpoint, are arbitrators required to have professional indemnity insurance cover? There are cases where parties have sued an arbitrator. Sam, have you ever been sued? Kethi?
Hey, I've been sued, but in a way of
They're
setting
asking about negligence. I don't know what your experience is. I would want to hear from you and Kethi as well.
Well, not for negligence, but mostly in cases of setting aside. You are named as a respondent in setting aside, but not in terms of negligence. I would say this: it is important, in as much as the Act provides for immunity of the arbitrator. It is good to always protect yourself. And this was an amendment that was brought into the Act in 2009 amendments, where we have section 16B providing for immunity of the arbitrator, that as you carry out your work as an arbitrator, you and your staff who are involved in that arbitration are immune when carrying out your office as an arbitrator. Of course, that will not cover some things like misconduct and other things, such that I have seen cases, and to answer, the direct answer is yes, I have seen many cases of arbitrators being sued, and those who are in social media or mainstream media will know there is a live case that has exploded about an arbitrator being sued. So yes, arbitrators are sued, and it is good practice to get yourself professional indemnity. Like any other professional, get yourself some indemnity in the event, for example, you are found to have misconducted yourself by avoiding an obvious challenge. It says parties to appoint arbitrator, and you're appointed by AAK, which was not in the contract. You say you have jurisdiction, and then you're found to have proceeded without jurisdiction in order to return the money. It's good to have a policy to cover you in such events. But when you're diligently doing your work as arbitrator, despite what views parties may hold, you're immune from any action, just like a judicial officer is immune when they're doing their work. So good practice, get yourself professional indemnity. There are various insurance companies that give for that, and they are affordable depending on the kind of practice that you're having. But yes, you will be sued as long as you are dispensing justice. But in my experience, I've only been a party in a setting aside, which has not succeeded, I must say, but not for any other thing like negligence or gross misconduct.
All right. Thank you. Kethi, anything to say about that? And as Kethi speaks, Sam, you can prepare your parting shot. I can see you have about 7 minutes, so about 2 minutes closing remarks. Kethi, you can answer that and close your side. I'll also, for participants, put some contact details there in case you have any questions. You have an area that you wish could be discussed in a like this one, you reach out to me and pass the message to the chat. I just put my number there. You can call, better WhatsApp, not call. Thank you. Over to you.
Yes, I've had the fortune of having not a single award I've given been applied to be set aside so far. I hope it stays that way. I've also not been sued in that capacity. They call it a learning curve because learning never ends. It had never occurred to me that as an arbitrator, a professional indemnity cover is important. So it's also a learning point for myself. As arbitrators, as advocates, it's very important, I believe, that when as a party you're considering the arbitrator to appoint, their training is important. There's always the assumption that good advocates make good arbitrators, or experienced judges make good arbitrators. Good arbitrators are made by training, so that you know the law, you have the tools, and you know what to do when the parties are before you. Institutions are also important, as some had mentioned. Under the NCIA, the registrar remains in copy of all correspondence. Under the institute, as I said, there's monitoring in terms of you have to follow certain guidelines. As an institute, it's an ongoing conversation as to how much we can do to make sure arbitration remains respected in the country and in the region. Much more can be done, but as advocates, I will say you must ask yourself, the person to whom you're taking your client for arbitration, do they have the training? If they do, chances are many of the arbitrations that you have seen challenged in court would not end up there, because the arbitrator you're before understands the task before them. It is 4 minutes to 4. There are still 112 people in the forum. It's not my place, but I'll say thank you to everyone who joined us today and for the engaging questions. Thank you, Peter.
Thank you very much, Kethi. Sam, closing remarks?
Yes, good drafting can help you avoid a lot of booby traps, and where the drafting is bad, be courageous enough, either a party representative or as an arbitrator, to ask parties before you whether they are amenable to entering into a post-dispute clause that makes sense for the process to proceed. Somebody had asked where they can get the advocate's remuneration order for the non-lawyers. I've answered in the chat. If you go to kenyalaw.org, you can get the advocate's remuneration order. But something more dicey and important, since the Act talks about parties being represented by a representative of their choice. I've been an arbitrator where a QS, an engineer, etc. is representing a party. Yet, advocates remuneration order talks about remuneration of advocates for offering their service. So how do you assess the fees of a QS who was acting, quote unquote, as an advocate in a case? Now, these took quite a learning curve, but because some of them come with the books that determine hourly rates for quantity surveyors. But remember, in this case, they are not acting as quantity surveyors in the dispute, they're acting as party representatives. So you find that in such cases, it's something that is just determined based on pre-existing contractual agreement. That parties went and appointed a QS because it was a technical construction dispute. The QS becomes their lawyer in the disputes, and therefore you follow the agreement between the party and their representative on how they will be paid fees. Secondly, market forces come into play, good practice. So yes, to determine reasonability and proportionality, you can use the advocate's remuneration order as a benchmark to see was what was agreed proportionate, was it reasonable, such that I can award this engineer or QS this fees. So they are not offering QS or engineering services, so their scale will not apply, but you can use the advocate's remuneration order to test market trends and forces and proportionality of what to award. I thought that is something that I should add because we are dealing with people who deal with these issues every day. Otherwise, just like Kethi, I want to say thank you very much to the people who are still on the forum and for FCIArb giving us this opportunity to share our learnings and experiences with our colleagues. Thank you very much, Peter.
Thank you, Sam. Thank you, everyone, for attending and staying to the end. It's been a very informative session. We did not anticipate that it would go on for 2 hours, but we are exactly 2 hours in. And thank you very much once again.